For the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Your Honor, Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Could I just have, Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right. So we have 4 sets of motions. The first one that I would like to address.
Free my boy Tidsy.
What was that, Jim?
I don't know what that was.
I think it was somebody on Zoom.
Yeah, nobody can speak, so it only could have been maybe. I think well said.
All right. So the first motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Free my boy Billy Tibbetts. Free Billy in the trap.
Kevin, could you just be either mute or watch us?
Jim, that's not me. It's somebody else is saying, free my boy Billy Tibbetts. It's not me.
Okay. Thanks, Mr. Reddington.
Thanks.
Go ahead, Mr. Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but
Fuck off, Beverly.
maybe I didn't.
Go ahead, Mr. Jackson.
Thank you, Your Honor. I want to try to save some court time and judicial resources. If the court is inclined, given the Commonwealth's position that they are in agreement with us to issue the summonses, I'll just submit on the papers and be done.
I have third parties that need to be heard.
If the court wishes, I'm happy to address the third-party concerns once they are heard.
No, I'll hear you now.
In terms of the papers that were filed, and my understanding is Mr. Reddington joined on Ms. McCabe's behalf with Elizabeth Proctor's motion and her position filed by her counsel. It basically comes down to a singular issue, and that is one of privacy. They don't have standing to argue Lampron. They're not parties to this action. It appears the Commonwealth, who is the party to the action, has agreed that Lampron, the elements of Lampron have been met with our request insofar as it is concerned, specifically and addressed to Michael Proctor, Trooper Michael Proctor, and his communications with Jennifer McCabe, Elizabeth Proctor's communications with Jennifer McCabe, Jennifer McCabe's communications, counter-communications with Elizabeth Proctor, and Michael Proctor's communications with Brian Albert and Nicole Albert. I'll address the issues that counsel raised in his moving papers on behalf of Elizabeth Proctor, because that's the only writing that I have to go on at this point. He basically argued that there are false statements made about Michael Proctor's relationship with some of these other parties. Since the very beginning, and that brings up the fundamental issue, Your Honor, of what is that relationship and what's the nature of the relationship, and why do we believe that that relationship establishes extrinsic evidence of bias and an inability to be neutral. From the very beginning of this case, we have questioned the neutrality and the bias of Michael Proctor and certain other government witnesses. Based on overwhelming facts that we've learned, overwhelming facts that establish that both this investigator and this investigation are compromised. That's why we...
Do you have that, Tori? Okay. Go ahead.
Thank you. That's why we've asked for the communications that the Commonwealth has now agreed with. Our request is nothing short of critical to our defense, obviously, and it's based on Ms. Reed's constitutional right, as established in Davis versus Alaska, the U.S. Supreme Court constitutional right, that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation, or any other government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabes. That's the relationship, and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors and the McCabes and or the Alberts. And he said there's no such relationship, zero. This doesn't exist. As a matter of fact, the word that he used was, it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabes or the Proctors and the Alberts is a lie. His words. So the DA himself has put Trooper Proctor's neutrality at issue, and he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court, he didn't address the Commonwealth, he is the Commonwealth, he didn't address us, the defense. What he did do is he addressed the public and the potential jurors, and that was by design. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, with a person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie, it's a photograph. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together, they're in a wedding together, in the wedding party. There's a third photograph.
And
Trooper
when was
Proctor-
that? When
I'm
was
sorry?
that? When was that?
2012. So this relationship, as the court just noted, and I was about to get to in a second, is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship. They weren't just at the same event. They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships, and they can't change that. Trooper Proctor was seated at the same table, having dinner with Colin Albert, Chris Albert, and Chris Albert's wife, Julie. Then there's the Facebook post, and I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask, Mr. Morrissey, who's actually lying in this case? Is it us? We just presented the court with factual information that was procured off of social media that it's unassailable. It cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date, for more than a decade. They've socialized with him, and his family considers their family to be so close and interconnected that they are deemed a second family to the Proctors. And who exactly are members of this Albert family and or McCabe family? Let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law, Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle and the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting. No, he never disclosed it. We found out about this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the best that counsel for Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe. Or maybe not. The suspicious part is Trooper Proctor isn't saying. And there's nothing in Elizabeth Proctor's motion to suggest that he wasn't home. Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by asking the question, does it matter if Trooper Proctor was home? They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a professional connection. It shows a personal connection. And according to the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case. They weren't talking about sports. They weren't talking about the weather. They were meeting about this case. So how does that not show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points, in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote, Michael Proctor has been fully vetted, end quote. He said there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said it's not like, quote, these people know each other, end quote. And he went on to say it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote. The Commonwealth said that because these facts would surely illustrate a conflict of interest. They would surely illustrate an undeniable bias. And those comments, Your Honor, I would suggest have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to these communications. And that turns on the question of asking, how could Trooper Proctor be expected to adequately and honestly investigate this case as the lead investigator, and also investigate the Albert McCabe involvement in this case, with this history of an interpersonal relationship and allegiance to those very people, the very third-party culprits, the very people who should be suspects in John O'Keefe's murder? And the answer is he cannot. And since the authorities, including Michael Morrissey, apparently have vouched for Trooper Proctor, my client, our client, Ms. Reed, is entitled to question and to test that voucher, and that's what we're seeking to do with the communications between Elizabeth Proctor and Jennifer McCabe. And insofar as that request is concerned, it's unquestionable that there are privacy interests at play, but I would suggest the following: that the constitutional due process rights of any criminal defendant in any criminal case hold a paramount significance because they form the very backbone of the justice system that this court presides over. And protecting those rights, such as the right to a fair trial, such as Ms. Reed's right to the presumption of innocence, that ensures an equitable trial and an equitable process. And while privacy rights of Elizabeth Proctor, a third-party witness, are obviously an element of concern and consideration for the court, they must yield to the imperative of a fair trial. And that imperative means Ms. Reed's ability to confront and properly cross-examine all witnesses, including Jennifer McCabe, including attacking the credibility of government witnesses, including Jennifer McCabe, based on bias, and that is fundamental to our justice system. So striking this balance ultimately upholds the integrity of the very system that this court is making sure exists and continues throughout the process of this trial. Elizabeth Proctor's privacy rights, while they exist, especially in light of the narrow focus of our request, are vastly outweighed by our client's right to a fair trial. And with that, Your Honor, I'll submit.
All right, thank you. Mr. Lally, are we going to hear first from counsel for Ms. Proctor, counsel for Ms. McCabe? I got an appearance this morning of counsel for the troopers as well. Is counsel for the troopers going to address us?
No, Your Honor, that's in reference to another motion.
Okay, so I will hear counsel for Ms. Proctor.
Thank you, Your Honor. Good morning.
Good morning.
Andrew Kettlewell for Elizabeth Proctor.
Good morning, Mr. Kettlewell.
So this is not a balancing test between the defendant's right to a fair trial, which is obviously constitutionally protected and paramount to our system, and Elizabeth Proctor's privacy rights. This is a request to bring evidence before this court for the purpose of trial under the mechanism of Rule 17 that is not within the framework of Rule 17. And I'm sure the court has had the opportunity to review our papers. Our sole basis of an objection is not Ms. Proctor's privacy rights. That is obviously a paramount concern to any third party, and the interest in not being harassed or brought into a criminal matter or a civil matter that that individual has no involvement in is obviously of interest to anyone. But as it relates to the standard here, the question is whether the defendant's request satisfies the 4 prongs of Lampron and the basis of Rule 17. And the defendant's request, I would submit to the court, fails on 3 of those 4 prongs. And I'm not going to belabor the facts underlying this whole situation. My brother laid out his case. That is laid out quite clearly in his affidavit as well. What I would say about the facts is, with regard to the first prong of admissibility and relevance, while hearsay that is reliable is certainly sufficient as a basis for a subpoena to issue, hearsay which is not a basis for a subpoena to issue. And in this case, my brother's affidavit essentially amounts to a large collection of conjecture and allegations which are not supported. With regard to the motion and the opposition that I filed, I appended an affidavit that lays out the basis for why I assert what I assert in my affidavit, and that's essentially conversations with individuals who have personal knowledge of where Michael Proctor was on the night of September 25th, 2023, individuals who have personal knowledge of the connections between, as my brother says, these two families, and who have personal knowledge relating to the actual photograph that my brother didn't mention in Exhibit C of his affidavit of Michael Proctor with two children who are still minors, who are not children of Jennifer McCabe. Essentially, the relationship between these two, quote, families is a distant connection that involves 5 separate steps of relationships between, I guess I'll call them relatives. Mr. Proctor's sister has a friend whose sister is married into the Albert family. And that's Chris Albert, not Brian Albert. And so what brought these different families to a wedding in 2012 was the fact that Mr. Proctor's sister, or Elizabeth Proctor's sister-in-law, was getting married, had her friend at her wedding, and her friend's sister and her family also wound up attending that wedding. The fact that Colin Albert and Michael Proctor were in the same wedding party, I think, is mitigated somewhat by the fact that Colin Albert was about 10 years old at the time and served as a ring bearer because he was a child. So the connections that my brother tries to lay out in his affidavit, I would suggest, are not what that affidavit makes it seem. Regardless of all of that, there's still issues on admissibility and relevance under the first prong of Lampron. And the reason for that is the defense actually includes a description of this September 25th meeting between Elizabeth Proctor and Jennifer McCabe and why that meeting occurred in a state police report that it actually appends to its motion. And whether or not a court down the road agrees that that area of testimony is valid grounds for exploration for impeachment of Ms. McCabe, what's occurring here is that the defense is attempting to use that as a basis to go get another layer of even more extrinsic evidence on the hope that something that's in the phone of an unrelated third party might impeach Ms. McCabe in an area that is already potentially a grounds of extrinsic evidence for impeachment. And that is not what is permitted under Rule 17. That is a hope, that is a conjecture, and that is not the purpose of the rule. And I'm not going to belabor the point for the court because I know the court is very familiar with Rule 17, but the purpose of the rule is to bring into the court for inspection and for purposes of trial records which are going to be admitted or are likely to be admitted at trial. It is not for discovery. It is not for exploration, whether or not that exploration the defense believes is part of its case or not. It's a question of, are those records going to be admitted at trial, and do we know they exist? And the defendant hasn't made out any of those factors at this point. The defendant is essentially assuming that there are records, does not know what is in those records, and as a basis is requesting. And that is not a Rule 17 motion, that's a discovery motion. And with regard to that kind of last prong of Lampron, I think the defendant makes clear her basis for the request in counsel's affidavit, as I cite in my opposition. And that's thus the communication surrounding this, parentheses, and other meetings, which again, the defendant has no basis to believe there might even be other meetings, close parentheses, may reveal information necessitating further pretrial motions, including a motion to dismiss based on extraordinary governmental misconduct. And that's the purpose of this Rule 17 motion, but that's not the purpose of Rule 17. The purpose of Rule 17 is to bring into court relevant and admissible records. These records are not relevant to an issue in this case. They would not be admissible under any rule of evidence. And based on what's actually asserted by my brother in his affidavit, nothing about that assertion meets the rule of Rule 17, meets the requirements of Rule 17. The fact that communications may reveal information right off the bat fails, and the fact that they are looking for these records as they might necessitate further pretrial motions, including a motion to dismiss, is entirely anathema to Rule 17, which is designed to bring records into the court for purpose of trial. And so, based on all of those and what I lay out in my papers, I would ask the court to deny the motion.
All right. Thank you very much. Mr. Reddington, do you want to add anything? I do have your motion to join in the opposition that was just argued by Mr. Kettlewell, but do you want to add anything to that, sir?
No, Your Honor. What I would do is basically, as I indicated in the motion, is join in on the motion, noting the objection of Jennifer McCabe, obviously asserting her privacy rights, obviously suggesting, as counsel just did, that this is a clever maneuver to try to kind of weaponize Rule 17 to turn it into a discovery motion. We all know that the September 25 meeting was about harassment and what these two women had been going through on the news media with the extreme harassment that they were suffering as a result of their being witnesses on a case and cooperating with the government's prosecution of Ms. Reed. So I suggest to the court that comments like the records may reveal and they possibly would show, which is what's in the motions that's before the court, clearly shows that there's no basis, there's no factual basis to determine that these are relevant material records other than speculating that they may reveal. Just like the allegations that the photograph of the two young kids would be Jennifer McCabe's daughters, and they're not. And it's so frustrating to the McCabe's and everybody else because they know whose kids these are. The parents know that they're their children, but nevertheless, they consistently suggest that this is showing that he's sitting there with these two kids that are the McCabe's children, and therefore, as counsel argues, this is evidence of extraordinary governmental misconduct, which is a wild accusation to be making at this point. And I suggest to the court that weaponizing Rule 17 is not proper. I join in the government's request initially objecting. And the fact that counsel has indicated that the government basically concedes and assents and does not oppose should not interfere with Your Honor's analysis of Rule 17 as opposed to any Rule 14 or any discovery motions that would be appropriate before the court. Thank you.
All right. Thank you very much. Do you want to respond, Mr. Jackson, before I hear briefly from the Commonwealth?
Very, very briefly. Your Honor, I would simply, to the microphone, I would simply note as to my brother's arguments, eloquent as they may be, they missed the mark. Obviously, this is relevant and admissible. Again, I don't believe that Elizabeth Proctor has standing in the court to actually argue Lampron, but since it was brought up and since that seems to be the foundation of her argument, I do want to address one point. There's a case that was cited by my brother in his moving papers called U.S. versus Abel. It's found at 469 U.S. 45. It's a 1984 case. It does not stand for the proposition that is propounded in the paperwork. Indeed, that is a federal case, not a state court case. That's the first line of distinction. Second of all, it is a mischaracterization of the holding in Abel to say that the scope of impeachment is the outer limits. The scope of impeachment is limited to the outer limits of taking the witness's word for it. And I would simply bear upon or ask the court to review the actual holding in Abel. Justice Rehnquist does not state that the scope of impeachment is limited to, quote, taking the witness at the witness's word or taking the answer of the witness, end quote. But rather the court specifically held that it's permissible to impeach a witness by showing his or her bias, and that's all we're seeking to do. In the court's words, Justice Rehnquist's words, quote, "A successful showing of bias on the part of a witness would have a tendency to make the facts to which the witness testifies less probable in the eyes of the jury than it would be without such testimony." And that's found at page 51. Contrary to counsel's misunderstanding of the holding of Abel, our impeachment of this witness is not limited to taking Jennifer McCabe's word for it. We're entitled to extrinsic evidence about her bias, about her lack of neutrality, about her attacking her credibility. This evidence is clearly relevant, it's clearly admissible, and the Commonwealth concedes as much in its opposition paperwork. And with that, I'll submit.
Mr. Kettlewell, did you need to respond in any way? Okay, sure.
So I'm not going to debate Abel because the court can certainly read the case. But essentially, it's the defendant's burden to meet Lampron. The defendant bears the burden to get the court to issue a subpoena and has to show all four of those factors. And it's not about whether the Commonwealth objects or does not object, and whether I have standing beyond an issue of privacy or not, which I would argue that a third party whose records are being sought certainly does. It's a question of whether they have met those elements, and they have not.
All right. Mr. Reddington, did you need to add anything to that?
No, Your Honor, I'm good. Thank you.
Okay. All right. Does the Commonwealth want to argue this in any way?
Just briefly, Your Honor.
Okay.
Thank you, Your Honor. Not to belabor the point, but just to make the Commonwealth's position clear, the Commonwealth is not opposing. The Commonwealth, however, does not assent, does not concede anything as it relates to any sort of relationship or whatever is being termed as a close personal relationship. The relationship, as the Commonwealth understands it, between essentially Trooper Proctor and Ms. McCabe is that Trooper Proctor has a sister who has a friend, who has a sister, who has a husband, who has a brother, who has a wife, who has a sister, who is Jennifer McCabe. And it's such a close personal relationship that after apparently scouring social media, there are exactly 0 photos that counsel has produced of Ms. McCabe and Trooper Proctor pictured together at any point in time. And essentially what you have to establish this close personal relationship is a wedding party from a decade ago and some photographs of Trooper Proctor with children purported to be Ms. McCabe's children, which are not Ms. McCabe's children. But given the limited scope of what is being asked for, the Commonwealth is not opposing the motion, but would obviously request that if the court were to allow the motion, that both sides would have equal access to inspect and copy whatever screenshots are then provided by the record holders, that being the third-party witnesses. Thank you.
All right. I'll take this under advisement. Mr. Reddington, you're free to leave, but thank you for attending. You're free to stay, too, but... all right, so now we'll do the motion regarding the Commonwealth's motion for protective order pertaining to the DNA profiles of the investigating law enforcement officers. So I'll hear from the Commonwealth first, then I will hear from counsel for the officers, and then I'll hear the defendant's opposition. Who's arguing this for the defense?
I will be, Your Honor.
Okay. All right, I will hear you, Mr. Lally.
Thank you. So, Your Honor, just to clarify on this, just a point I think may be misconstrued based on the defendant's opposition. This is not a situation in which these troopers have consented to anything at this point. The purpose of filing the motion was to try to gain some guidance from the court as to how mechanisms would be concerned with the collection of DNA, the retention of DNA, the destruction of DNA, and the timing in regard to that prior to obtaining either Trooper Proctor or Sergeant Buchanan's consent in relation to the taking of any bugle swabs. So How this sort of arises is there is DNA reports in relation to the taillight of the defendant's vehicle. There are 3 possible contributors to that DNA mixture. One is positively identified as that of the victim, John O'Keefe. 2 others are unknown. There's been rampant sort of speculation, accusations levied against these particular troopers in regard to contaminating evidence or planting evidence and things of that nature. So the exploration of this is sort of caused by that, in the sense of the Commonwealth believes that whatever DNA comes back, it would exclude those 2 troopers as being contributors to the unknown sources of DNA. So what the Commonwealth is seeking, and the reason that the Commonwealth actually filed another motion asking for sort of an expedited response from the defendant, is the hope of the Commonwealth, especially with March 12th jury trial date looming, was my hope was that there would be some sort of agreement that could be come to and a joint proposal to be presented to the court so the court could act on the papers, and this testing could be well underway, if not already completed, by the time that we reached today's court date. That unfortunately was not what happened. So we received the response earlier this week from the defendant. Essentially, most of the proposals that are included within the defendant's opposition are the precise alternative proposals as far as the protocol as the Commonwealth had laid it out. So as far as the defense not wishing for anybody associated with the state lab or state police to be collecting the sample, that's fine. We had proposed Ms. Christina Owens simply because she's a civilian member of the Crime Scene Services section. But if it, as long as it's a certified collector, it doesn't have to be anybody associated with that. The defendant has some issue with the state police crime lab conducting any of the testing, whether that be generating the sample or doing the comparative testing, and seems to be fine with that process proceeding at Bodie and Lorton, Virginia, where some other testing related to this case is already being done. That's fine with the Commonwealth as well. Obviously, that's going to prolong things a little bit, I would submit.
Do we know that?
I mean, what I can say is that our office would certainly be inclined to pay whatever additional fees would be necessary to expedite that testing. But as far as the time frame is concerned, I really can't say exactly how long that's going to transpire for. But as far as it seems to be sort of the main sort of point of contention is the defendant's ability or access to the actual sample. That is something I would object to. As far as, particularly in this case, I don't think there's really going to be any question that the samples or the profile that's generated is the profile of the individual troopers. It's going to be collected by an independent certified collector. It's going to be the DNA profile will be generated at an independent lab. The comparative analysis will be generated at an independent lab, and counsel would certainly have access to those DNA profiles should the defendant wish to compare it to any other types of any other pieces of evidence or any other DNA that either they recovered during their evidence inspection or that was collected by the state police in regard to their investigation. So the need for the actual sample, I'm not really sure where that comes from, and the suggestion that the Commonwealth would have more access to it than the defendant would, especially if the court is inclined to go with the alternative suggestions of the independent collector, the independent generation of the profile, and the independent comparative analysis. I really don't see what defendant's access to the samples does or lends to any sort of credulity to the testing or to any further testing that the defendant wishes to conduct. So as far as That, I think, really the only other sort of disparity or sticking point is the retention. The Commonwealth had suggested the end of the trial process, the reason for that versus what the defendant is suggesting as far as the conclusion of the appellate process is obviously the close of the trial process has a much more definitive end frame to it as opposed to the appellate process that could go on for months and years, if not after. And given the limited nature for which the Commonwealth is seeking the consent of these troopers to conduct this DNA analysis, it certainly made more sense to myself and to the Commonwealth as far as setting that time period if the court wishes to alter that to the conclusion of the appellate process. There are other mechanisms I would suggest that the defendants could avail themselves of should they have a need for, again, the profile would exist sort of in perpetuity in their possession, at least until the end of the appellate process. And there are obviously far more mechanisms available today than there have been in previous years as to post-conviction discovery and obtaining further samples, things of that nature. So again, that was the reason for the suggestion for the end of the trial court process. Again, the purpose of this motion was to seek the court's guidance as to exactly what the parameters of that collection, retention, destruction, and all of that would be, so that that can be presented to the troopers so that they can make an intelligent decision as far as their consent is concerned.
If this were ordered to be done at the state lab, when would the results be in?
That, I think, especially given just prior turnaround time in relation to other testing that's been done in this case, at the state lab, I would hope that could be completed within 6-7 weeks, something like that, at the most.
Okay. Do you want me to hear from Ms. Lundgren now or after? I mean, this is your motion. Do you want me to hear from her now?
I think that's fine as far as the order's concerned.
Okay.
Gretchen Lundgren, Your Honor.
Good morning.
Good morning, Your Honor. Thank you for hearing from me on behalf of Sergeant Buchanan and Trooper Proctor in a discussion as their privacy interests as it relates to the Commonwealth's motion for a protective order. The proposed protective order strikes a balance between protecting the sensitive and personal DNA information of two individuals who are not alleged to have had anything to do with the death of John O'Keefe, while giving all parties access to the resulting scientific DNA analysis. The defense's opposition casts the proposed protective order as allowing the Commonwealth to obtain, test, and analyze the samples without giving them the same opportunity, but that's simply not the case. There are areas of significant agreement between the parties here. Both parties are willing to have an independent law enforcement officer obtain the DNA sample. Both parties are willing to have an independent lab develop the DNA profile and conduct the comparative analysis. Both parties will receive the same reports and underlying data. Once an independent lab develops the DNA profiles, Your Honor, there should be no need for anybody to have access to the sample thereafter. And with an independent lab conducting the comparative analysis, there should be no need for anyone to have to conduct further testing. And finally, Your Honor, once the trial is over, there should be no need for those DNA materials to be on file. And as Mr. Lally said, the legislature has provided a mechanism for obtaining third-party DNA post-conviction. So there's certainly a safety net there if the DNA is needed post-trial. Your Honor, protecting the troopers' DNA samples and profiles through these procedures and protocols poses no violations of the Commonwealth's mandatory discovery obligations. The Commonwealth and the defense would be on equal footing with regard to the troopers' DNA evidence. Each party is free to argue the implication of the results at trial as they see fit. As Your Honor can appreciate, my clients are under no obligation whatsoever to provide their DNA in this matter, but they seek to take steps to demonstrate the integrity of their handling of the taillight evidence. In order to provide consent knowingly and voluntarily, they're looking for certainty surrounding who has access to their DNA how their DNA is handled, and ultimately how their DNA is disposed of. On behalf of my clients, Your Honor, I respectfully request that you issue the protective order proposed by the Commonwealth.
All right, thank you very much. Mr. Yannetti, it sounds, when I read your opposition, I did not know that there was this much agreement. Did you when you filed it?
I did not, and quite frankly, hearing the argument from both counsel, I think there's even more agreement than I anticipated.
Okay.
Your Honor.
What do you disagree with?
Okay, so our position, Your Honor, is at this point, with regard to the DNA samples versus the DNA profiles.
So where are you in your opposition? What page?
So I'm actually going to the Commonwealth's motion itself with regard to how the DNA samples and profiles will be treated.
Okay.
We did not realize that the Commonwealth was drawing a distinction between the actual samples themselves and the profiles that were generated. It was our understanding that the Commonwealth was seeking to prohibit the defense from having access to either. But I've just
Okay, but they're not.
Exactly. I've heard Mr. Lally say today that they will turn over the profile to us. That satisfies us.
Okay, I have a question for you.
Yes.
Since you mentioned Bodie Laboratories, you're the first one that mentions it in the pleadings. How long will it take?
We're not the first ones that mentioned it. The Commonwealth mentioned it in their motion, and we agreed to that.
All right, I don't have that.
Your Honor, it is one of the alternatives that the Commonwealth had. I'm sorry, I can find
Okay,
that.
so we need to find the paper number. All right, but we need to know how quickly that can be done, and we need to see about expediting it.
Typical for Bodie, just because I've recently gone through that with regard to the hair sample.
Right.
It's, I think, like a 12 to 14 week turnaround without any sort of expedition. So, you know, expediting, I don't know that necessarily that can be cut in half, but it is something that I think can be turned around a little bit quicker than their typical turnaround time.
And Ms. Lundgren, you'll have your clients available, you know, at the drop of a hat to provide this sample? Yes, Your Honor. All right, so go ahead, Mr. Yannetti.
Thank you. So, Your Honor, I think the only real conflict at this point, if the Commonwealth is holding to their motion, is their paragraph 7, which states the defendant is not permitted to conduct independent analysis or testing with either Sergeant Buchnick's or Trooper Proctor's DNA samples or profiles. Now, clearly, we won't do that with regard to the samples because we won't have them. We don't need them. But we will have the DNA profiles, Your Honor, and once we do, they, in my view, in my client's view, we should be able to use them for any case-related purpose. We have no interest in, distributing them anywhere or doing anything with them.
Hold on, Ms. Lundgren, I think you should answer this. Why don't you come on up? Is there an opposition to that?
I just need you in front of a microphone. There's one right here. Thank you.
She could take this mic if she likes.
No, because we'll be going back and forth, so you should stay there.
There is an opposition, Your Honor. I mean, I think perhaps the Commonwealth can speak to it. I think there's also a strategic decision, a case-related decision. Certainly, we agree with the privacy interests that the troopers are providing their DNA for a specific reason and with regard to a specific item in this case. And they do want to limit that consent. However, that is more, I believe, a case-related and strategic reason that I would also defer to the Commonwealth to speak to.
All right, I'll hear from Mr. Lally afterwards. Go ahead. Not now. I'll hear from Mr. Yannetti to finish.
Right. So there is other evidence in this case where comparative testing, DNA testing, could be done. And in addition, Your Honor, I want to make it clear that our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that there's consent and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's admission today, that should be evidence that either side can use for any proper purpose that is case related. So we should not be prohibited from either requesting or doing our own comparative analysis from those DNA profiles if it relates to the case.
What do you want to say, Mr. Lally? We're talking hypotheticals here.
We are.
Right.
So what I would say is the only other identified evidence really, or the bulk of it as far as DNA is concerned, concerns Mr. O'Keefe's clothing, which I don't understand what any relevance that would have pertaining to the trooper's DNA profiles. As it pertains to what ifs, as far as any sort of other physical evidence that counsel would come into possession to, the protective order, while somewhat ironclad, is not necessarily cement. So if there's a request for a modification based on subsequent evidence or something like that, I think that's something that the court can obviously entertain at that point. But really, the purpose of this is with reference to that one specific item.
It does make sense that if there is something later, you come before me on it.
Well,
So that's why I asked you if it's hypothetical. If you have an item that you know you want to test, I think the Commonwealth has every right to know what that item is.
okay, our position would be that we should be able to conduct our own investigation in private and reveal the results of those investigations, of that investigation, should we desire to. We have a different ethical duty than the Commonwealth. Clearly, if there's any evidence that the Commonwealth possesses that we'd like to do comparative testing on, we have no choice but to notify the Commonwealth and resolve any disputes before this court. But if we come into possession of anything that we believe is related to this case and should be tested, we don't believe that's any business of the Commonwealth to interject in that. We will have the profile at that point. We can do our own testing and then reveal the results of that testing should we desire to.
All right. Does the Commonwealth want to be heard?
No, Your Honor.
All right.
May we have just a quick second, Your Honor?
Yep.
My co-counsel brings up a good point, which is after months and months and months of requesting access to the physical evidence, we finally appeared at the Norfolk County DA's office on December 1st of 2023 with our forensic DNA collection expert, and he did swabbings of multiple pieces of evidence. So we do have those in our possession.
All right. I had no idea what you were talking about when you were saying hypothetically.
Well, there are two separate issues. There are the items that we've swabbed that we should be able to test, and if we have the DNA profiles of these troopers, there should be nothing prohibiting us from testing them. And by the way, the Commonwealth has the ability to do the exact same testing on their own. And then if there's any other evidence, I still maintain that we should be able to do comparative testing on that as well.
All right. Let's get the samples going. Let's do that, and I'll figure out the rest of this. But let's get who do you have in mind for an independent collector?
Your Honor, I don't have anyone specific in mind, but most local police departments have at least someone who is a detective who is a certified collector. Is
there someone the defendant? The two of you work out something.
I don't have any issue with working out something with Mr. Lally.
All right, so let's do it today.
That sounds good.
All right, and Ms. Lundgren, you'll make your witnesses available immediately?
Yes, Your Honor, but I just, for sake of clarification, just trying to understand, and as Mr. Lally said, they have not provided their consent yet. They are waiting to hear what the boundaries of the proposed protective order will be in order to provide that, knowing and voluntary consent.
Okay.
So, I mean, we could certainly potentially do the samples and hold them in abeyance and not release them if the court was willing to have them destroyed should the troopers decide not to provide consent based on the bounds of the protective order. But certainly I think they do need to know what those terms are before moving forward.
All right. I need to look at this. I'll do it as quickly as I can. All right. Is that it on this?
Yes, Your Honor.
On this
All right.
motion, yes.
All right. So the third and the fourth motion are sort of in their own category. So the third motion is, it's interesting in that I received the opposition, or the opposition to motion for protective order was filed before the motion for protective order, as I had it in the docket. Who's arguing this for the defendant?
This is the protective order regarding the letters, Your Honor?
Yes.
I will be arguing.
All right, so
Given to us December 4th. It was filed yesterday.
So what I can say, Mr. Yannetti, is that it appears that you served counsel for the Commonwealth with this motion, but you did not serve the U.S. Attorney's Office. So the U.S. Attorney's Office has a right to be heard on this order, on this proposal that you have. So I need them here. I need them served. So you can serve them and we'll get a date.
That's fine, Your Honor.
All right, and we'll do it as soon as possible. I do not want to change the trial date in this case. This case will go to trial on March 12th. And the fourth motion, where I said the third and the fourth are sort of in the same category, the Commonwealth's motion for records from Boston Magazine, that needs to be appropriately served and have someone here from Boston Magazine if they oppose it.
Yes.
So I'd like to do this as soon as possible. And given our trial schedule and the fact that I intend that we try this case in March, I'd like everybody served for a hearing here on January 18th at 3 o'clock in the afternoon. It's a Thursday afternoon. So it's just about 2 weeks. Should give you enough time if you serve these people today to get them here.
Can you do it?
We can do it via Zoom where it's
Your Honor,
discrete issues, yes.
we're in trial on January 18th. It's a short trial. Is there any other day that might work for the court?
I don't see any time that we can.
Is the 16th at all possible?
No.
No, no.
Oh, that's right on the back of the holiday, isn't it?
We're both supposed.
I understand that. No, it's not available. We start a trial Monday.
We're both supposed to be in trial that day.
All right, so you can do it via Zoom, or Mr. Yannetti can do it.
I can certainly do it. There's no chance of the 23rd, Your Honor?
No, there's no chance that week.
Okay.
If they had been served, we would have gone forward with that. I'm more concerned about that one, getting that one rolling,
Understood.
than the other one, all right? So January 18th at 3 o'clock. All right. Anything else we need to talk about? Doesn't appear to be.
Your Honor, I think it makes sense to raise this one issue, which is today was the filing deadline for all non-evidentiary motions.
Right, and none have been for evidentiary motions.
Okay.
Today was the filing deadline for evidentiary
Okay.
motions to suppress, things like that.
I understand. So the defense will be filing before the end of business today, not evidentiary motions, but non-evidentiary motions one motion to dismiss and one motion for sanctions and also for disqualification of the Norfolk County DA's office from this case. So,
All right, so you were not filing motions to suppress.
Correct.
So they're being waived.
correct.
All evidentiary motions are waived.
Correct. Well, yeah, we'll have pretrial motions in limine. I don't know if they would.
Okay, but everything else, so,
But in
okay.
terms of constitutional issues.
So file them by the end of today, and if we can hear them on that date, we'll do that on the 18th.
Right, and that would, depend on Mr. Lally ability to respond, et cetera, which, I understand he may need some time, but they will be filed today.
Okay. All right, thank you all.
Your Honor, there's several I apologize. Your Honor, there's several housekeeping matters I wanted to address with the court. In regards to the motions to dismiss that Mr. Yannetti, my brother, just discussed, We do have a motion to dismiss the indictments in this case, and I wanted to lodge the grand jury minutes with the court. They are very voluminous. I wanted to ask for the court's guidance on how you would prefer to receive those.
So when that happens, we typically get them on a flash drive, as well as, Jimmy, how are they filed with you?
Counsel have filed by email and then followed up with the grand jury minutes. So they can do it by a thumb drive.
All right, so a thumb drive, but get a separate one for
We'll
me.
mail that to you so that you'll have a hard copy, the thumb drive. The other housekeeping issue I wanted to address with the court, Your Honor, is, as you know, the court has ordered the Verizon records relating to Jennifer McCabe, as well as the Google Nest records. We were informed by the clerk's office those were supposed to be produced to the court on December 15th. My understanding is you guys have not received anything, and I wanted to follow up on that because that obviously is evidence that we hope to have in advance of trial.
All right, so Mr. Clerk, is your office call or is counsel call?
I've never called.
Yeah. So typically defense counsel calls and says there's a court order, where are these records?
I emailed the clerk's office, and they said that they haven't received anything yet, and so that's why I wanted.
Right, so call Verizon and call, who's the other record holder?
Google Nest.
Contact the record holder and say there's a court order, where are these records?
Okay, but
Okay.
you all have not received anything.
I don't know. Jim?
Yes, I'm thinking.
Have you received them?
Could counsel come to sidebar?
Okay.
Absolutely.
Quiet, please. What's still on record?
Free can't read. Free turtle boy.
That's it.
Your Honor, if I may, just one last thing, just with regard to the motion to dismiss, as far as does the court want the exhibits that were presented to the grand jury in addition to the minutes, or just the minutes?
Yes, I assume where you say it's so voluminous, it's the exhibits as well, Ms. Little?
I can produce.
You have to stand in Massachusetts. Thank
Yes,
you.
I can produce the evidence as well.
Okay. All right, so everything.
And I don't have a problem providing that to the court as well. I don't want to duplicate matters, but
Okay.
if it's easier, I can do it. It's fine.
So those would obviously be provided under seal, Your Honor.
Of course, they're grand jury minutes.
Correct. That's with regard to the motion to dismiss, the basis of which is the grand jury presentation. The separate motion...
Is it McCarthy or Odell?
Both.
Okay.
With regard to the second motion for sanctions, Your Honor, the letters that were the issue of the protective order that the Commonwealth moved for, that we've now put off, those will be part of the quote-unquote evidence with regard to the motion for sanctions. It's our position, obviously, that those are not exempt from public disclosure. However,
I'm going to keep them exempt until we hear from the U.S. Attorney's Office.
that's why I raised the issue, Your Honor. I just
All right,
wanted
was
to let
that
the
your
court-
suggestion as well, so we could get moving with this motion to dismiss?
Of
Okay.
course. Thank
All
you.
right. All right. Thank you.
Thank you, Your Honor.
All rise, please.
All right, so, thank you.
So we're going to go to the DA's office now tomorrow?
You are muted.
To get your
That's not the point. The point is, I've never seen a circus like this. There have been 110 murders or more.
You can go ahead, yeah.
I've been part of. I've never seen anything that's a quarter of this. It's bananas. Grindeder, I sat watching Dr. Grindeder kill his wife in 1999.
No, I don't.
Had $1 billion defense. Mike's on.
What I would say is just go there, check in on the front desk, ask for Lieutenant Tully, he knows you're coming.